Watson and Associates are federal government contract lawyers who help small businesses throughout the United States and overseas with many issues regarding federal government contracts. Please subscribe to our channel at the end. Please call us to discuss how you can get paid what you deserve when there is a termination for convenience on your government contract. Have you ever wondered what happens when a government contract is terminated for convenience? It's a situation that can occur under various circumstances and carries significant implications for the contractor involved. When we say termination for convenience, we are referring to a clause found in government contracts, specifically under FAR 52.249(2), that allows the government to terminate the contract when it's in their best interest. This could be due to a multitude of reasons, perhaps a shift in budget allocations, change in project scope, or even a strategic redirection. Whatever the reason, it's not always a reflection on the contractor's performance. So, what does this mean for the contractor? Well, upon receiving a termination notice, they are obligated to submit a final termination settlement proposal to the contracting officer. This proposal must be submitted promptly and within a year from the termination's effective date, unless given an extension. Stay with us as we dive into the chronological process of contract termination and its implications. What happens immediately after a contract termination notice is received? This question might be buzzing around in your head, especially if you're a contractor working with government contracts. So, let's dive into your obligations post-termination notice. The first step involves submitting a final termination settlement proposal to the contracting officer. Now, this isn't just a simple submission. It comes with a certain format and a prescribed certification, both of which your contracting officer will provide. But wait, there's a clock ticking. This proposal needs to be submitted promptly and definitely before a year from the effective date of termination. That's your deadline. But what if you need more time? Is there a possibility for an extension? Yes, indeed. The contracting officer may extend your deadline if you make a written request within the 1-year period. Now, you might be thinking, what happens if I miss this 1-year deadline or the extended deadline? Well, there's a provision for that too. The contracting officer, if they find the facts justifying it, can accept and act on a termination settlement proposal even after the 1-year deadline or any extension. Once you've submitted your proposal, the next step comes into play. Now, this is where things can get a bit tricky. If you, the contractor, and the contracting officer can't agree on the total amount to be paid due to the termination of work, the contracting officer will decide the amounts to be paid. This decision will be made without duplicating any amounts agreed upon under paragraph F of the termination for convenience clause. So, we've covered the immediate steps after receiving a termination notice. You now understand the importance of a final termination settlement proposal, the timeline for submission, and the possibility of extensions and exceptions. You also know what happens when there's a disagreement on the termination settlement. But remember, the process doesn't end here. Let's explore what happens if there is disagreement on the termination settlement. Stay tuned as we delve into this in our next segment. What if the contractor and the contracting officer fail to agree on the termination settlement? This question often looms large in the minds of contractors. When disagreements arise, the contracting officer steps in to determine the payout. First, the contracting officer will calculate the contract price for any completed supplies or services accepted by the government that haven't been previously paid for. This would be adjusted for any freight and other charge savings. Next, they will sum up the costs incurred in the performance of the terminated work, the cost of settling and paying termination settlement proposals under terminated subcontracts, and a reasonable profit sum. However, if it appears that the contractor would have sustained a loss on the entire contract had it been completed, no profit is allowed and the settlement is reduced to reflect the indicated rate of loss. Bottom line is that if the contracting officer and the contractor cannot agree on the terms, this can be considered an impasse and could be reviewed as a Contract Disputes Act claim, providing the document meets the CDA requirements. However, be clear that a termination settlement proposal, by itself, is not a Contract Disputes Act claim. Lastly, they'll account for the reasonable costs of settling the terminated work, including accounting, legal, clerical, and other necessary expenses. Now that we have discussed the disagreement process, let's move on to the appeal process. What if the contractor disagrees with the termination decision? This brings us to the heart of our discussion, the contractor's right to appeal. This right is enshrined under the Disputes Clause of the Federal Acquisition Regulation, or FAR Section 52.249. 2. Now, let's delve into the scenarios where this right can be exercised. The contractor can challenge any determination made by the contracting officer under paragraphs E, G, or L of this clause. This means if the contractor disagrees with the termination decision, the calculated settlement, or the handling of the termination inventory, they can appeal. However, it's crucial to note that this right to appeal isn't absolute. If the contractor fails to submit the termination settlement proposal or request for equitable adjustment within the specified period, the right to appeal may be forfeited. At the law firm of Watson & Associates, LLC, we bring decades of hands-on experience in the federal procurement marketplace. We help government contractors throughout the United States and overseas. Let us help you get paid the amount you deserve after a valid termination for convenience decision. Please call us at 1-866-601-5518 today.